One point which is important to visualize our discussion is that we have a cyber crimes, but we don't have a cyber jail. We have to keep in mind that very often we think only on the internet as a global infrastructure. But yes, internet is global in its functionality, but it is very local in its effect.
Welcome to the Education for Justice Global Podcast Series. Cybercrime can be perpetrated by offenders anywhere in the world with an internet connection. This episode discusses the transnational nature of this crime, challenging traditional notions of jurisdiction, and explores the jurisdictional conflicts posed by cybercrime and digital evidence. I am Kamoli Ibragimova, the UN Office on Drugs and Crime, Education for Justice focal point for cybercrime. We talk about the jurisdictional conflicts posed by cybercrime and digital evidence with Professor Jovan Kurbalija, the founding director of Dipla Foundation and head of the Geneva Internet Platform. Compared to other types of traditional or offline transnational crime like drug trafficking, trafficking in persons or firearms, what are the unique challenges that cybercrime poses in terms of jurisdiction?
Cybercrime is both new and old. You have to make clear distinction between this old element, continuity element, and new element. On the old side, I would say that sometimes we overestimate novelty of cybercrime. We overestimate novelty of the cyberspace. But if you really think carefully, you can see that whatever you do online is ultimately linked to the space, whether computer web from which we are accessing or recording this podcast or the flow of data across the cables. Ultimately, any internet transaction, digital transaction can be anchored in the physical space. And it is of utmost importance for discussion on jurisdiction. This is this old aspect and we can apply it to. And there is then the new aspect. The new aspect is related to the speed, use of new technology, interdependence, and those digital elements, mainly in the way how traditional crimes are conducted and organized. Whether it is drug trafficking or trafficking in person or firearms, there is always this digital layer. And lastly, there are a few crimes which are specific for digital world, mainly crimes affecting confidentiality, integrity, and availability of data and computer systems. Therefore, this is this interplay between old and new. One point which is important to visualize our discussion is that we have a cyber crimes, but we don't have a cyber jail. Therefore, that element of the implementation of punishment is still very traditional. Now, that interplay between fast flow of data, exchanges, interdependence, and anchoring it into the jurisdictional principles built around the question of procedural jurisdiction, substantive jurisdiction, or enforcement jurisdiction, and finding this jurisdictional link, which could be territorial principle, the link between transaction or legal entity or personality who committed cybercrime and particular territory. This is the first principle. The second is personality principle, is the right of state to rule over its citizens wherever they might be, and this is increasingly used. And effect principles, the right of state to rule on economic, security, legal effects of the cybercrime on particular action. Therefore, this is the major challenge, where to find this connecting link between action that triggered the cybercrime in digital space and those three principles, territoriality, personality, and effect.
So, given that countries primarily claim jurisdiction over crimes committed within their territory, what are the various approaches that the countries use to defining when a cybercrime is committed within a country's territory?
Building on the previous comments, they can make this connection between conduct that triggered cybercrime and the jurisdiction around a few elements. One is the question of data. Where is data stored? Data that was involved in cybercrime activity. Because there is also interplay between data, more passive part, and the communication or interaction in cyberspace. But data is important part. The second element is services offered. Therefore, you basically discuss where is the service offered by internet service provider or internet company, regardless the question of data, and going into the complexity of the cloud computing. Because as you know, modern internet companies and the digital industry move data easily within the networks and the servers which are located in different jurisdictions. I personally tend to believe that it's better to focus on this element of services. And the last element is basically the question of effect. Where are the people, companies, and societal interests affected? Where does it happen? Because we have to keep in mind that very often we think only on the internet as a global infrastructure. But yes, internet is global in its functionality, but it is very local in its effect. Therefore, that element of effect is sometimes even on the level of local communities, cities, municipalities, but definitely on the country's level. Therefore, in brief, one possibility is data. Where is data stored? The second one is where services are offered, legal incorporation of internet service provider of company. And the third one, where the effects are felt and considered and impacted society.
As you mentioned, internet is of global nature, and data which is stored in one jurisdiction, in one country, can be accessible, viewed, and downloaded from multiple other countries. What are the approaches to the criminal justice responses in a situation where content is illegal in one country, but legal to produce and disseminate in another?
We have now quite considerable jurisprudence, academic writings, and thinking about this challenge of cross-border impact of the cybercrime. And in 2001, we will celebrate soon 20 years, there was Yahoo case in France, where French court ruled that possibility of French citizens to access materials, the Nazi objects stored at the Yahoo websites in the United States, that possibility was the breach of the French law. And French court requested from the Yahoo at that time, almost 20 years ago, to prevent access to French citizens to this Nazi materials at the Yahoo website. And it was legally an interesting case. Yahoo objected, obviously, because of the First Amendment, which rules the freedom of information in the United States, but ultimately they basically removed some of the data. And at that point, discussion of geolocation started. And Windsurf, in his expert opinion to French court, said that to the large extent, it is possible to filter the access according to the IP numbers. Now, as you know, geolocation has really developed very, very fast since 2001. And I would say that technically speaking, and we're speaking about technical aspects, it is now quite straightforward to identify where from particular content is accessed. Therefore, geolocation and the key role of internet service providers in this context are possible solution for this challenge of transborder access of material, which is in one jurisdiction perfectly legal, as it was the case with the Yahoo materials in the United States, but in the other jurisdiction illegal, as it was the case with the French law about Nazi materials. Therefore, geolocation is a technical solution, and I would say that on that point, we have a relatively clear situation. The impact of geolocation may be negative on the economic transaction, sharing of information, but legally speaking, for the question of cybercrime, it is technically almost solved problem.
As you also mentioned, when it comes to asserting jurisdiction over cybercrime, countries use several principles to establish the connection with the cybercrime. Like you mentioned, wide interpretation of the principle of territoriality, as well as number of additional bases like nationality, either of perpetrator or of the victim, protection of interests of the state, universality, which enables countries to assert jurisdiction over cybercrime. And this can potentially create conflicts whenever serious cross-border cybercrime occurs that multiple states have an interest in prosecuting. So which factors could be guiding for addressing issues of concurrent jurisdiction?
The question of concurrent jurisdiction is becoming quite prominent and complex for various reasons. One is the interdependence of the internet, of digital transaction. Therefore, we are getting into contact with the people from other jurisdictions more often than in traditional world. This is the underlying challenge. But there is also challenge of the extension of jurisdiction through the different internet-related laws. For example, as you know, General Data Protection Regulation protects data of European citizens even beyond the territory of European Union. Therefore, it poses in different areas, not in cybercrime, the question of potential conflict of jurisdictions. Cloud Act, other national acts are increasingly extending jurisdiction beyond the national shores. Therefore, it is becoming a major problem. We can use traditional tools in the international criminal law to some extent, but also from the conflict of laws or international private law, which has a much more developed jurisprudence of the conflict of jurisdiction around basically procedural jurisdiction, which court or state authority has the proper right to take the cybercrime case, substantive jurisdiction, which law should apply in the specific case, and enforcement jurisdiction, how should court the decision be implemented. Therefore, these are three elements. Now, while we will navigate this increasing complexity, there are few low-hanging fruits that we should use. One is the question of developing standards accepted by national juridical and legislative bodies. Second is consolidation of language. Language is very diverse, use of terms, use of the definitions. And the third one, not so low-hanging fruit, but still much less complex than drafting the new legal instruments, is harmonization of national legislation when it comes to the conflict of laws and deciding on procedural, substantive, and enforcement jurisdiction. In brief, increasingly complex issue, difficult to regulate on the global level, but there are some possibilities to make life easier for the courts and enforcement agencies through development of standards, consolidation of language, and harmonization of national legislation.
Some countries, when it comes to access to extraterritorial data for criminal justice purposes, attempt to impose this obligation on service providers which are in possession, custody, or control of data, regardless of whether such communication record or other information is located, to provide these data. But as you also mentioned, this service provider can operate in other country where this country imposes on this service provider obligations of data protection, and these standards are varying from country to country. So what are the implications of a direct law enforcement access to extraterritorial data for data protection requirements in this context?
The first part of electronic evidence is to make a clarity of terminology. We speak about data, and here we have diversity. Is it a traffic data of internet traffic? Do we speak about log files of internet service provider? Is it a content data, or is it, for example, data about subscriptions? Therefore, there is a diversity of different data and different type of privacy protection rules that should be applied. Now, most of the countries worldwide face the similar dilemma: how to ensure that they have access to data and evidence, and how to protect the privacy at the same time. And this dilemma is basically centered around the question of powerful encryption. Technically possible, it's possible to encrypt the data, and as we saw in the FBI Apple case with the San Bernardino terrorist attack, that was the major dilemma. And this is a cross-cutting issue. Therefore, we may think of some sort of more proactive international cooperation, even some legal instrument, on the access, on dealing with this dichotomy between access to data for the legal enforcement and protection of privacy. This is one of the few commonalities that all states worldwide have as a challenge, and that's also linked to the question of surveillance. Practically speaking, one has to observe due process, introduce standards, use existing multilateral legal assistance treaties, and insist on lawfully collecting data. Technically, it is possible to collect the data, but the focus should be on the due process and lawful collection of data, and resist that temptation which technology provides. Because by using these technical shortcuts and bypassing legal processes, we are shaking the legal basis of the internet and the global society. Well, that's essentially the key message: diversity of data, delicate balance between protection of privacy and access to the evidence, possible instruments that can help in regulating surveillance or coordinating surveillance, ensuring that we are not tempted by technical possibility to access data across the border and bypass lawful channels and due processes. There is a point on criminal justice purposes, but we can also reflect on the broader question of data, on the data. For example, GDPR introduced this element, we can say personality jurisdiction, that wherever data of the European citizens is hosted, it should be regulated by GDPR. And this is, I would say, one of the most important legal developments. Therefore, legislators in the European Union said, we don't care what you do. I would say one solution is to go to this service element or service link, approaching the internet service provider, which is basically providing services or tech platform, and making them accountable under the national jurisdiction and not getting into the question of data. This is why I was initially a bit skeptical about the question of location of data. Therefore, internet service provider is established under, it's a company established under the national law. It has a responsibility, including responsibility under the criminal law, not only a civil law. Basically, it is the first point of contact. And you then skip all that complexity if data is moved from server to server. That's probably one solution which many countries can adopt. And of course, personality solution that link the data protection or cybercrime investigation to the individuals. This is one possibility, but I would say this is more question of geopolitics, digital geopolitics, which players like European Union or United States or China have much more clout to impose that jurisdiction than smaller countries. The main challenge in the cybercrime field on international level is to move beyond the silos of crime or cybercrime, criminal justice, and to ensure that cybercrime solutions are built around a multidisciplinary approach by connecting the dots between ministries or government departments on the national level in charge of data, security, e-commerce. And if you analyze carefully access to data and evidence for cybercrime, you can see this interplay. You will go to internet service provider and you will basically as a national authority and you will request the data and internet service provider will have to deliver data. But behind that, there is a very complex data protection regulation and I would say in some situations even e-commerce regulation. Therefore, the first point is to connect the dots and to find a solution on national and hopefully later on international level that can take into consideration this interplay. Currently, there is a lot of confusion. There are different levels of privacy protection and data protection internationally, and the major friction in the global internet governance is basically around these differences in data and privacy protection. But I would say it exists also on the national level. Therefore, the first point of contact is somebody who provides service, and those are internet service providers, or if big tech companies are registered in national jurisdiction. Governments will put pressure on them. That's quite simple and clear, and it's a natural solution. But then one can push them beyond proportional on data protection on e-commerce. Therefore, if we want to have solid economy and if we want to have observing of human rights, that has to be comprehensive solution. These days, we have to make a trade-off on the question of COVID. We can isolate citizens and make confinement as it is needed sometimes, but in the same time, there is a risk for economy. I would say that delicate trade-off, multidisciplinary trade-off is much needed in this question of access to data and evidence.
Sincere thanks to Professor Kurbalia for his time and insights into the topic of cybercrime jurisdiction. Let's inspire change together and let's work together to achieve the Sustainable Development Goals. Higher education matters, and the United Nations Office on Drugs and Crime is proudly partnering with hundreds of universities from around the world to advance the Sustainable Development Goals. Education for Justice initiative is part of the global program for the implementation of the Doha Declaration, funded by the State of Qatar. Tune in for the next episode of this E4J Global Podcast Series that will be published soon on our E4J platform. In order not to miss any of our next podcasts or opportunities for higher education institutions, please register yourself at our Education for Justice platform. Let's inspire change together.